People who are listening might be saying, well, if they're criminals, let them get their DNA, because if they have their DNA, then it's going to help solve a crime in the future. But what about the databases where, like I know in Minnesota, and I don't know where else, I hope it's not California, but where as soon as a baby is born, they take the DNA. What about those databases?
Well, to answer your question, but I'd like to get back to forensic DNA databases because
Okay.
I question some of the assumptions that people might make about them. But yes, there's a huge growth in medical databases. Newborn screening is one of the large growth areas. Every newborn in this country is tested for several dozen heritable disorders at birth. Blood spot is taken, and many of those blood spots end up in biobanks. And there have been numerous instances where consent has not been reached. There was a large case in Texas most recently where a large database of newborn screening samples had to be destroyed because none of them had been obtained with consent from the parents of the children that were born at the hospitals.
Right. Well, let's get back to, I didn't mean to make an assumption that everyone whose DNA is taken, who's arrested, should give up their rights, because I don't. So let's kind of go back to that.
Sure.
Because I was telling you
to talk about
yeah.
forensic DNA databases, I think there's this underlying assumption that the bigger is better.
Right.
That the more samples we get in the database, the more likely we are to solve crime. That's not necessarily the case. For multiple reasons. For one, the types of crimes that are routinely solved by with the help of forensic DNA databases are the type of crimes for which forensic DNA databases were originally created. Violent crimes where biological samples are likely to be left, such as rape and murder and such. But forensic DNA databases are of no use for many types of crimes for which DNA samples are being taken. And there is generally often no statute of limitations on keeping those samples in the databases. And those databases, as I said, are being increased to include individuals who are entirely innocent.
Right.
People who've been arrested but never convicted.
And that's California.
That's California and other states too. And bear in mind that alongside many of these official databases, we've seen instances in many jurisdictions where individual law enforcement departments are keeping their own private databases off the record. And we've also seen instances where individuals who are stopped by the police are offered the opportunity to give up a forensic DNA sample to be included in the database in exchange for being let off. And these are oftentimes for petty crimes. So there's, and this is all concurrent with the fact that we now have, in most law enforcement jurisdictions, massive backlogs in terms of processing samples because we're just taking a lot of samples.
And that,
and the law enforcement does not have the ability, the means, the funding to process many of these samples.
You know what? That was just recently in our newspaper about how our Orange County District Attorney's Office is got backlogs and backlogs of DNA, and they've been trying to get money and resources to deal with it, and it is a mess. So, by taking everybody in who's been arrested, then you don't focus in on those really important type crimes, like you said, the violent crimes, those crimes where that would really be helpful to them in the DNA.
That's exactly right, and it goes even further. The CODIS, which is the main national database that is kept by the FBI. The FBI has prevented any research on their database, so we actually know very little about how effective the size of the database is in terms of many of the claims that have been made by the FBI and law enforcement.
Oh my goodness! So they don't even have any accountability.
Well, there's no. I mean, the samples in there are genuine samples. So in terms of actually using the database for purposes of catching criminals, I mean, I wouldn't want to imply that that isn't a good thing.
Right,
I think it's a question of making sure that resources are used most effectively and that individual privacy rights are respected. There's absolutely no reason that both can't happen concurrently. And it's the same thing with other types of genetic databases in the medical context. This is really not a one or the other type of proposition. Sufficient regulations by no means would stop research, by no means would stop proper law enforcement, and
it might just make it more effective.
And it probably would focus resources to make them more effective.
Yeah, exactly. That's what I was just going to say. It would focus it to make it much more effective. We are speaking today with Jeremy Gruber, who is the president of the Council for Responsible Genetics. And he has been a longtime privacy advocate, and he has dealt with the ethical and environmental implications of all of the emerging genetic technologies. He's testified before Congress. He's written many things. And just recently, they released the Consumer Genetic Privacy Manual, which if you're listening to this, and this stuff is very important and I think a little bit disconcerting at this point, you might want to go to their website, consulforresponsiblegenetics.org/genetic privacy, and you also can download this great manual that talks about all the science of genetics and helps you understand some of these issues. So, we haven't really talked yet about the discrimination issues. So let's talk about the genetic discrimination.
Sure. I mean, when you have obtained an individual's genetic information, and I'm not talking about you being a doctor or a researcher, but any other type of entity, that information is highly valuable. It can be predictive of future health conditions, which can be valuable for a number of different contexts, and to be honest, many times that can be exaggerated. Many of us, I think that genetics and genetic information is dispositive of your future health. It's not. We're only at the beginning of really understanding how genetics interplays with the rest of your body and the environment in terms of how diseases manifest themselves. But genetic information is highly valuable, and it can be used in a number of contexts to discriminate. It was certainly the impetus for our work on state and federal legislation, and we have recently passed federal law that does protect against the use of genetic information, at least in the health insurance and employment context. But there's a lot of different entities that potentially could want that information. Banks might not offer you a mortgage if they thought you were going to pass away before the term of your loan. People might want to process the DNA of politicians might want to process the DNA of other politicians. People might want to check out the DNA of potential people they might want to marry. I mean, there's a whole host of areas where people might use DNA inappropriately.
Even employers, right? Employers might decide that
was the two areas that were the biggest impetus for passing the Genetic Information Non-Discrimination Act were the two areas where we were starting to see discrimination at a very early stages in the process, and that were employment and health insurance.
Right.
Employers who would want to gather genetic information, both because they were concerned about the high cost of health care and didn't want to take on or maintain employees who could potentially be expensive, notwithstanding employees who might have to leave their employment and they would lose money in training and other areas, and then of course health insurers who were concerned about dropping individuals who might be expensive liabilities on their insurance. I mean, we were seeing many instances in both contexts for a number of years, which was the impetus for passing state and federal legislation. Probably one of the most noteworthy in the employment context was a case that I worked on a number of years ago regarding Burlington Northern Railroad. And I think it's sort of an indicative of the potential for how genetic information can be misused. In that case, there were a number of workers who worked on the tracks for the railroad in Nebraska. They developed carpal tunnel syndrome from working with heavy machinery. They filed workers' compensation claims, and as part of the normal processing of these claims, the railroad took blood samples. Unbeknownst to the workers, they took additional blood samples that were to be run genetic tests on for carpal tunnel syndrome, ostensibly with the purpose to disallow the claims as pre-existing conditions.
Oh, my goodness.
Fortunately for the workers, one of the workers' wives was a nurse, and she noticed the amount of blood being taken as inappropriate for the normal procedures, and an inquiry was made, and the whole case was discovered, and the railroad eventually settled with the Equal Employment Opportunity Commission for those infractions. But I think that was not uncommon. It was certainly not regular practice among employers, but we saw a number of instances of this, and which was the impetus for passing a federal law.
Yes.
And that law, Genetic Information Non-Discrimination Act, covers employment and it covers health insurance, but it certainly doesn't cover many of the other areas potentially in the future where genetic information could be misused. We have no comprehensive federal legislation in this country protecting genetic privacy.
And is that, was that brought up with HIPAA? I mean, was that really addressed in any of the HIPAA legislation?
Well, HIPAA does address the genetic information in the context of, to a certain degree, in the context of group plans in health insurance. But it didn't and does not apply to individual insurance market, and certainly didn't apply to employment, and it of course doesn't apply to many of the other areas where genetic information is routinely gathered.
Right. You were talking about with that case with the trains that the blood was taken and it was really without their consent or permission or even knowledge that they were taking it to test their genetics. What about other ways that your genetic information can be taken without your permission?
Well, there are many areas where genetic information can either be taken without your permission or taken for one purpose and used for another, which is often the case as well. Everything from your doctor, from a visit to the doctor, whether it be for your own health, whether it be for reproductive issues, to if you use one of the direct-to-consumer genetic testing companies that are proliferating to test your DNA for certain conditions, to as we discussed, some of the forensic law enforcement purposes that we're talking about, to participation in clinical trials for research. So there are a number of areas that we're already seeing genetic information being accessed, and I think we're likely to see far more in the future. If you look at the strides that are being made in gene sequencing machines, I think we're going to see a lot more integration of genetic testing in medicine and in other consumer contexts in the future.
Yeah, you always see on these crime-solving television shows where, for example, law enforcement grabs a cigarette and they take the DNA from the cigarette, or they take it from a glass. Even that, they can get your DNA, right, from your saliva.
Oh, absolutely. In fact, surreptitious, we call surreptitious DNA testing, is a real potential problem in this country. We have no national law that governs the taking of individuals' DNA. We leave DNA wherever we go, whether it be in our saliva or in our hair or in our skin, and that information can be accessed and used